A certain politician in a public speech has called for the eradication of a certain religion or religious culture. In a democratic country whose constitution has vested in the citizens certain freedoms, is such language acceptable? Lawmakers, politicians, and civilians have the right to speech, but there must be a line. Where is this line? Let's try to figure that out. Article 19 of the Indian Constitution promises its citizens the right to freedom of speech and expression, to assemble peaceably and without arms, to form associations or unions, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, and the right to practice any profession or to carry out any occupation, trade, or business. This article also allows the laws to impose reasonable restrictions on the exercise of the rights conferred by the freedom of speech and expression in the interests of the sovereignty and integrity of India, the security of the state, friendly relationships with foreign states, public order, decency and morality, or in relation to contempt of court, defamation, or any incitement of an offense. It is important to note that the freedom is available only to citizens. Recently, the Supreme Court has ruled that the fundamental rights under Article 19 can be enforced even against persons other than the state or its institutions. One of the laws putting fetters on the freedom of speech and expression is Section 153A of the Indian Penal Code. Section 153A punishes the promotion of enmity between different groups on grounds of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to the maintenance of harmony. Section 153A, Clause 1 stipulates that anyone who by words spoken promotes or attempts to promote enmity, hatred, or ill will between religious communities shall be rewarded an imprisonment which may extend to 3 years or a fine or both. Section 295A of the IPC deals with deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion or religious belief. Any person by words spoken shall be granted imprisonment which may extend to 3 years or a fine or both. Section 298 of the IPC deals with offending an individual's religious feelings through words or sounds or gestures in the individual's vicinity. Punishment may extend to 1 year or fine or with both. Section 505, Clause 1, Subclause B and C deals with people who make, publish, or circulate any statement, rumor, or report with intent to cause or which is likely to cause fear or alarm to the people or to any section of the public, whereby any person may be induced to commit an offense against the state or against public tranquillity, or with intent to incite or which is likely to incite any class or community of persons to commit any offense against any other class or community, such person or persons shall be punished with imprisonment up to 3 years or with fine or with both. Justice P.N. Bhagwati, who spearheaded judicial activism in India in Maneka Gandhi versus Union of India, underlined the importance of free speech, saying that a democratic society stands fundamentally upon unfettered debate, discussion, and open dialogue, as it acts as the sole corrective of government action. We can all agree that the citizenry of a democratic country has the right to question the government and bring forth errors in policy and decisions made by the people in power. However, hate speech is a different beast entirely, with not one single victim nor just one single perpetrator. The social importance of placing reasonable limitations to the right to freedom of speech is evident from the fact that one of the changes brought about to the Constitution of India in the first Constitutional Amendment Act of 1951 was the addition of three more grounds of restriction on freedom of speech and expression. These restrictions include public order, friendly relations with foreign states, and incitement to offense. This amendment also made the restrictions reasonable and thus justiciable in nature. The Supreme Court of India in Shaheen Abdullah versus Union of India and others has recently mandated to the police forces of all Indian states to suo motu register FIRs in hate speech cases attracting offences under section 153A, 153B, 295A and 505 of the Indian Penal Code even if no complaints are forthcoming, and any failure to do so would place the concerned officers in contempt of court. There is a glaring lack of clarity as to what constitutes hate speech. The provisions in the IPC that deal with hate speech are often vague and open to interpretation. These provisions are often used selectively by the police, and there have been numerous instances where hate speech cases have been registered against individuals who have criticized the government, which is not in the spirit of democracy, while hate speech by people who are politically connected have gone unpunished. This selective enforcement of laws is detrimental to the building of trust that the public should have in the judicial system.